Kwabena Adu Boahene and his lawyers are concerned about the demeanor of the judge at the High Court. They are alleging that the judge is not. They are alleging that the judge's role is not being played the way they expect it to be played. So Kwabena Adu Boahene here and his lawyers have brought legal action against the judge. And tomorrow the Supreme Court will be hearing the application, inviting the courts to endorse their suggestion that the judge be removed and the new judge placed there. It's part of legal procedure that you can ask for the judge to be removed and another judge placed there if you feel that the judge has exhibited bias, unhealthy bias against you one way or the other. But you have to cite cogent reasons why you think the judge has done so. And in the affidavit attached to the writ, Kwabena Adu Boahene cites those things. Let's look at them right here at the beginning. This is This is the Attorney General, the Dr. Dominic Ayeni, the Learned Attaching Counsel for Kwabena Adu Boahene, and this Deputy Attorney General Sremsai. All three of them very critical to the matter. Now, Adu Boahene seeks an order of prohibition against the High Court judge in the matter of the Republic versus Kwabena Adu Boahene. That's the way they say it in law. He's looking for an order to prohibit the judge from continuously sitting on his matter as a High Court, as a trial judge. They want the Lord Chief Justice to change the judge. If the panel of Supreme Court tomorrow were to agree with Attaching, then the Lord Chief Justice will have a duty to remove the judge and place another person there so that the trial can continue. So what are the reasons that Kwabena Adu Boahene is given or is asking for the courts to agree with him? Now, these are the summary of the reasons, and we'll go into the details in a minute. Reason number one, Kwabena Adu Boahene and his lawyer said that the High Court judge has shown bias by holding court sittings with the prosecution present while Adu Boahene was yet to be brought into the courtroom. They are alleging that. Two, they say the High Court judge has shown bias by insisting that he continues with the matter while there is a pending appeal against his decision. We'll explain this in some detail in the next page. And then number three, it says the High Court judge has shown bias by preventing Adu Boahene from having access to important evidence needed for his defense. So the High Court, so they are saying that the High Court judge constituted court at 4:30 p.m. They were not aware. They were bundled into a car and sent to the court. By the time they got to the court, they saw the Deputy Attorney General and the Attorney General suggesting that these important prosecutors were aware and that they, the other side, were not aware. They believe that is offensive to the Criminal Procedure Act 30, I believe. The second one, they are saying that the High Court judge has shown bias by insisting that he continues. So normally when they bring an application before a High Court judge, he can have a decision on it. He makes his decision. If the parties don't like it, they go to the Court of Appeal or the Supreme Court for a review of that decision. Now, they're saying that whenever that happens, typically the judge must stay the proceedings and wait for the court, especially if they are saying that without this matter, we can't move on to defend ourselves. The judge says, I don't mind, go ahead and defend yourself. But if they sue, as they say, they sue upstairs, and they're asking for a judicial review on the matter, typically the judge should hold. But they say that the judge says here, he says he's not willing to hold. Okay, so let's get into the details of the grounds. Ground one, which is ground one, is the High Court judge has shown bias by holding court sittings at an odd time. This is the case. On 30th April 2025, Angela J. Boateng, Charles Adu Boahene, and Mildred Donko and their lawyers were invited to meet officials of the Economic and Organized Crime EOCO. But after a 2-hour wait, they were unexpectedly detained by armed EOCO personnel and taken to the High Court, despite protests from their lawyers, Samuel Atachia and Kwame Oseasare and Peter Osea-Samoa. They were ushered into General Jurisdiction Court 10, that's a courtroom, where the Attorney General and his deputy were already present. The lawyers, caught off guard and not formally dressed for court, were served with a charge sheet and prosecution facts that had been filed earlier the same day. In violation of legal procedure requiring prior notice, it will mean that the charges were filed and the court made aware and made to sit the exact same day. The presiding judge, His Lordship John Eugene Nyante Nyadu, proceeded with the arraignment despite objections, and the group exited the courtroom at about 4 p.m., at about 6 p.m. Now, Kwabena Adu Boahene is saying that this is untoward, this is not part of the legal procedure. You don't surprise an accused person by asking him to come to an investigative agency, EOCO. He's at EOCO for 2 hours. He finishes, hey, come and sit in this car. He sits in the car, they are put in the car, and they are sent to a courtroom. Then the Attorney General is already there. The judge is there. It's past 4 o'clock, normal time for the courts to close, but this judge was sitting, waiting for them, and then they served them with a charge sheet, etc., etc. So that's ground one. Ground two, that the lawyers of Adu Boahene filed an application praying the court for an order directed at the Attorney General to disclose all the pages of evidence required. This included some pages of a bank statement produced by the Attorney General, as well as evidence of certain procedures that are used by the national security architecture. The application was because some of the pages of the documents provided by the Attorney General as evidence against Adu Boahene had been deleted and could contain important evidence to prove his innocence. Further, the court's order for national security to disclose its procedures would have aided the defense, show the court that what Adu Boahene did was standard practice in national security architecture and was not theft. So on this one, the Attorney General brought a document to the court to prosecute Adu Boahene. It's a bank statement from one of the banks. Now, the bank statement has about 100 pages, but the observation was that about 90 pages were taken out, and the court didn't see it. It wasn't in it. So the Adu Boahene's lawyer says, but what's going on? You have a bank statement that has Adu Boahene's transactions. It's 100 pages. Put all there. We will show you what you are looking for. We'll show you how it works. But you have taken this substantial amount out and you are submitting to the court a few documents. I mean, if this is true, it's quite bizarre. If it's true, it's very, very bizarre. You are a defense person. They bring your bank statement and they've taken some out. How are you going to deal with that? Why should the prosecution be allowed to do that in a democracy and in a normal court practice? So they are arguing against that. That's not correct. I mean, if this is true, this is very serious. Also, they say that the things that you are accusing Kwabena Adu Boahene for is a standard procedure of the national security architecture. Bring the national security people in. Let us ask them whether this is not their procedure. Whether in 1993 they didn't do the same thing. Whether in 2016 they didn't do the same thing. Whether in 2011 they didn't do the same thing. And then the prosecution says, no, I'm not going to do that. And they make an application to the judge. The judge says, I'm not going to allow you to do that. It is as if you want to tie his hands behind him and shoot at him. You don't want him to be able to defend himself because the material that he's going to use to defend himself is within the bosom of the prosecution. Sometimes they call it discovery in legal practice. But Adu Boahene is complaining about this as a second ground. The third ground, Adu Boahene says that, okay, so on the second ground where they are not allowing him to defend himself, he's relying on a recent case of Republic versus Bafuboni in which the current acting Chief Justice ruled as part of the matters. And it was said that they should allow the prosecution should give to the defense anything that the defense needs that will be needed for the evidence in aid of the defense case. Prosecution and the court should allow the defense to get everything that the defense needs, even if they have to get it from the prosecution, which will allow and aid the defense of his case. So Kwabena Adu Boahene cites this as the reason why he thinks that the judge should comply and allow them to get the full document of the bank statement and also the national security procedures. They should bring them to the court. Now, on the third ground, he says that upon refusal by the court's order, the Attorney General to provide full disclosure, Adu Boahene's lawyers appealed the decision by the judge, insist on continuing. Adu Boahene appealed the decision by the judge. I appealed the decision, but the judge insists on continuing the trial despite a pending appeal before the Court of Appeal. This is all on the backdrop of the judge acceding to request to the Attorney General to deal with certain matters earlier than has been fixed for determination in the court. So this is very, very, very concerning. Here, Adu Boahene's lawyers are saying that based on the fact that the judge says he will not allow them to get the full bank statement, they filed an appeal to the Court of Appeal, told the Court of Appeal that, look at this, we need this to defend ourselves, but the High Court judge says that we are not entitled to it. Now, whilst the Court of Appeal is preparing to hear the matter and give a decision one way or the other, the High Court is continuing with the trial. That whether you have it or not, I'm moving on. I'm going on with the trial. He may go on the trial and get to the end of the trial whilst the Court of Appeal is yet to bring the decision down. So they are saying that, no, let's go to the Supreme Court and say that based on all of these demeanor findings, we believe that this judge should be prohibited from continuing to hear the matter. The Supreme Court hears the matter tomorrow morning. Good luck to all parties. But we hope that the democracy is built as a democracy. It's not built as a democracy of an oligarchy, or it's not built as a democracy of some feudal state. Democracy is democracy. Transparency is important. The judicial strength is important. People must have the right to defend themselves. All of those ethos guaranteed by the 1992 Constitution must be very important. If a person is guilty, he's guilty. But let's not be hearing these things from the court, and let's hope that these things are not true. The Supreme Court will have their decision to make tomorrow when all of these matters are brought before them.